Hello, everyone. Welcome to the webinar today. So glad to have you with us on this lovely Tuesday. We have a really interesting topic today that I think a lot of you probably on the call have either had to deal with or maybe wanting to prepare yourselves for, which is the moment that a tenant stops paying you rent. What are your options? What can you actually do to make sure you get that rent paid to you? There are definitely strategies you can take. We're going to go through that in just a moment. Before we open up, though, I did want to make a couple of brief announcements. So one is we are recording this entire webinar as usual. We will be emailing it to everyone tomorrow along with our speakers' contact information and the slides, so you can review it on your own time. Or you could even share the recording if you want. We're also going to have time here for Q&A at the end. Of course, whenever we have an attorney and a rent reporting expert, we want to make sure we can get all those questions to our experts here while we have them. So make sure that you put your questions in the Q&A box, preferably not the chat. The Q&A box you'll see at the bottom of your screen says Q&A. That's a perfect place to put it so that we can better track your questions and make sure we don't lose them in the chat. To kick off this whole presentation, I'd like to ask you all in this poll, have you experienced late or unpaid rent? Go ahead and put yes or not yet in here, and then we'll go to the next slide where I can tell you a little bit more about our speakers today. Oh, yes, and the table of contents. But so briefly, if you want to take a look at this, this is mostly what we're going to be going through today. So talking about the problem, the steps that you can take, how to report that unpaid rent to the credit bureaus, protection against harassment claims, which is something that could happen when you are pursuing that unpaid rent, tenant move out owing a debt, what do you do? And then how do you find a former tenant once they do move out if you do need to collect on that money? And how do you warn other landlords lastly? So lots to cover today, and here are our speakers. So we have Grant Burwash. He is the Chief Operating Officer with FrontLobby, a rent reporting service. Grant basically has worked with FrontLobby, a leading property technology company helping housing providers reduce delinquencies, recover unpaid rent, and encourage on-time payments. He has an MBA from the University of Texas and brings a wealth of experience as a growth equity investor and entrepreneur. We also have with us Steve Williams, who's partner at Fried Williams and Grice Connor LLP. He's been representing real estate property owners through the Bay Area and California since 1999. We've had Steve come on and talk on many webinars now for several years. Steve is always great to have with his wealth of knowledge all about real estate law, including residential leasing, which is what we're going to be talking about today, rent and eviction control. So he'll be clarifying a lot of these laws that go along with this process of collecting unpaid rent. And of course, there's me. So I'm the Director of Marketing and Education here at the American Apartment Owners Association, and I host these webinars. I've been doing it for the last 10 years. We're 200 plus webinars in. So glad that you could join us if you haven't already in the past. I'm glad you're here. And then also for the poll question, I'm going to go ahead and share the results here so y'all can see it. So most of you have experienced late or unpaid rent, 89% of you on the webinar today, which is pretty high. So I think you'll all find some use, and those that not yet, great. I'm glad you guys are being proactive. So let's go over to the first screen here so we can talk a little bit about a case. I brought this up a couple weeks ago on a tenant screening webinar that I did. There was a couple who was charged with defrauding landlords. And this is interesting because we don't typically see this at a criminal level. But earlier this year in Baldwin County, Alabama, a couple was arrested for defrauding multiple landlords out of up to $80,000 in rent. So over the course of 4 years, they moved from property to property. They never paid a dime of rent. They dragged out the eviction process. They even were able to pause those or dispute those negative remarks from ever reaching their credit reports so that the next landlord wouldn't know about their history. And this wasn't a one-off. This is a perfect example of how this can happen to really anyone. And in this case, to multiple landlords consecutively, and how that unpaid rent can really become this long-term costly problem. And tenants are getting smarter. They're finding ways to work the system In this case, it's Alabama. It might be a little more difficult to do it in some more tenant-friendly states. So we'll talk about that. But we're going to basically cover here how you can protect yourself. And if something like this were to happen, what can you do to actually recover your unpaid rent legally and make sure that you're not the next victim of a repeat offender? I know most of you are really great with screening your tenants, but even when you do everything right, this can still happen. And so we want to really just dive into what are your options if it does occur to you. So I'm going to pass this along to Steve here. Before I do that, I have a quick poll question again, which is, do you currently have a process for handling unpaid rent? So those 89% of you or so that said that you've experienced this, have you implemented that process? Let me go back and stop sharing that poll so I can launch the new one. So yes, you have a process and it works well, or are you interested in trying something new, or no, you still struggle with this? So I'm going to let you all answer this for just a bit. And Steve, if you'd like to get started here, what can we do when rent is missed?
I think you're on mute right now, Steve. There you go.
Yeah, and sorry about that. Just to follow up on that Alabama nightmare, there are situations like that in California as well. I have come across what I call serial tenants, where I have had to evict the same person twice, and you have a slick speaking tenant who sneaks their way into a unit with promise, that they've got all this money and they're going to make large payments. They offer 6 months in advance or whatever it may be, and then no rent ever comes. And they sit it out until the eviction process runs its course, which can take many, many months. And then they move on to the next landlord and are paying nothing. So it does happen. Fortunately, it's not too common. I don't come across it very often, but it is something to be aware of. And as you point out, it makes the vetting process extremely important. Don't take the tenant's word for anything. Follow up with any resources you have to vet that person. Now, let's get into, well, when rent is missed, what can I do or what should I do? And it really, every case is a little bit different, but I don't typically recommend that you have the knee-jerk reaction to immediately give a 3-day notice to pay rent or quit. Generally, I think, especially if it's the tenant's first time missing a rent payment, that just reaching out to the tenant, finding out, hey, what's going on? Your rent was due, I didn't get it. Maybe there was a family emergency, maybe whatever, fill in the blank. There could be some situation where sometimes tenants forget that happens. That happens a lot. And so an open line of communication as your first line of defense, so to speak, not only keeps potentially the relationship amicable and professional, but it could, end up getting you paid, or maybe there was just some situation the tenant was dealing with, and you get paid without having to serve a notice or run to an attorney to help you with a notice. So that's always, probably the first, method that you can use to try to get your rent. Again, every case is different. I mean, if the tenant if you had to track the tenant down for 8 of the last 10 months rent, well, then of course you're going to deal with it a little bit differently. But just that initial missed rent, you may want to just reach out, and that can be by a phone call. Maybe you have an email communication, record with the tenant, and that's the way you typically communicate, or even texts. Again, this is very informal, this method here. So just any way that you're comfortable communicating with the tenant, or have already established a mode of communication, just reach out that way. I would strongly encourage that. Um, so another option, of course, is the notice to pay rent or quit. So if you've reached out to the tenant and you're not getting a satisfactory response, the rent's late and the days are running, and you're just not getting the rent paid, then the notice to pay rent or quit is an effective and very formal approach to put the tenant on notice. Hey, they better pay or else. This is the first step in what's called an unlawful detainer action, which is a court, it's a fancy word, unlawful detainer for eviction, an eviction action in court. This is the first formal step. The first legal step is the service of a 3-day notice to pay rent or quit. Now, historically, it's been pretty easy. You have a one-page 3-day notice to pay rent or quit, pay within 3 days, or else you're either going to be evicted or taken to collection. Typically, if the tenant pays, great. If they don't, you can then file your unlawful detainer action. But I want to highlight here a pretty adverse ruling that the Landlords Bar received about a month ago out of Southern California. There was a landlord there who served and I've seen a copy of the notice. It was a terrible 3-day notice to pay rent or quit. It looks nothing like what you may download from an organization who you're a member of in California, a notice that they may have prepared for this sort of situation. This looked like just a custom-made 3-day notice to pay rent or quit that was lacking in many regards. Unfortunately, the court sort of went sort of above and beyond with their decision and ruled the notice was invalid, but for a reason that is now impacting notices potentially statewide. It basically said that it may not be enough to tell the tenant you have 3 days to pay rent or quit. You may have to actually tell the tenant when the tenant was served with that notice, which is a little bit ironic here. I mean, how do you let a tenant know in a notice you're serving when that notice was served in the past? But essentially it said, hey, the tenant has to know when they were served and has to know when it expires. Otherwise, I think that the court's wording was, how could a reasonable tenant calculate when they have to pay the rent unless that information is contained in the notice? So the organizations the landlord organizations throughout California have had the reaction to immediately update their 3-day notices, as I have with my firm, to address this decision. But basically, you're going to want to have some sort of information there that lets the tenant know when they're being served, and possibly even when that notice expires. So it may not be sufficient to just say 3 days to pay the rent or quit, but to even take a step further, and that 3 days ends this date. So there is some push out there to get this case depublished, or at least a portion of it. But for now, I would recommend consulting with a lawyer to make sure that you've got the right language in your 3-day notice to pay rent or quit. If you have one that you have stashed away that you've been using for years, I would say scrap that and look for the latest and greatest version. So again, that was a bad case that just really set a bad tone and requirement for landlords when it comes to non-payment of rent cases. Another issue that comes up occasionally, and I'm seeing more and more tenant advocates raise this as a defense in non-payment of rent cases, and that is the landlord should be the one who makes the demand for unpaid rent, whether that's in your initial informal reaching out to the tenant, hey, you owe rent, or whether that's in a formal 3-day notice to pay rent or quit. So the landlord should be the person who's identified in the rental agreement. Let's say it's owner John Doe. Okay. John Doe is the tenant named in the rental agreement. Rent is paid to John Doe. Well, John Doe's sister, Jane Doe, should not be the one signing a notice. She should not be the one reaching out to the tenant for that payment. Similarly, even if they have a property manager, that property manager can certainly collect the rent and then give it to John Doe. But in some scenarios, that property manager should probably not be the one to sign that notice to pay rent or quit. Now, there are some exceptions if that property manager is named in the rental agreement as the payee of the rent. But generally, whoever the payee is should be the one making the rent demand. And the reason is because of some Fair Debt Collection Act practices that are required. Now, a third party can make the demand, but there's all sorts of disclosures that need to be made with that demand. Some paperwork has to be included. And I just point this out because it's pretty simple. Just whoever the rent's paid to, that should be the one who makes the demand, who signs the notice to pay rent or quit or whatever. Um, and that way you don't run afoul of fair debt collection practices and have someone else who's demanding that rent. And like I said, I am seeing tenant advocates who are raising that issue when they see someone else making the demand, aha, and they bring that up to the court and hey, this notice is bad or whatever. Um, Another thing to be aware of is, especially when COVID hit, a lot of organizations received significant funding to assist with tenants with their rent payments. If a tenant were to fall behind, they may be able to offer some rent assistance to get that tenant caught up. So there are rental assistance programs that have money in various areas throughout California. And so what they do is if a tenant has missed a rent payment, they can then, in some circumstances, actually pay that rent on behalf of the tenant to avoid eviction, to keep a tenant housed. And I bring that up here because I do see that a lot. And I oftentimes advise clients that that is likely going to be the outcome of serving a 3-day notice to pay rent or quit and filing an unlawful detainer action, that at some point, some sort of rental assistance may be offered. Um, so, and sometimes that doesn't kick in until an actual formal 3-day notice to pay rent or quit is served. So you may hit a tenant who's had a hard time and your informal efforts aren't working, but when you actually serve the formal notice, they take that to one of these programs and they may step up and hopefully help pay the rent to keep that tenant housed. And that seems to be the way a lot of these eviction cases are going these days and in certain areas throughout California. Another method, so we've talked about sort of the informal method, reaching out to the tenants, seeing if you can't find out what's going on and getting paid. We talked about the non-payment of rent notice option. Another one may be a small claims court. And maybe that's a scenario where the tenant has fallen behind, but it's otherwise been a good tenant. You don't necessarily want to evict the tenant. Maybe the rent they owed is a year or two old, which by the way, for a non-payment of rent eviction notice, you can only ask for rent that's outstanding within the last 12 months. So if you have some rental debt that's a little bit older than that, you can still pursue that in small claims court for up to 4 years if you have a written rental agreement. So that's another option is for unpaid rent, you can file a small claims court action. Now, there are statutory limits. If the rent that's owed is significant, generally above $12,500, you would want to go to Superior Court. But generally under that amount, you can seek it in a small claims court action. Again, it's the landlord who's owed the rent typically who makes the demand and files the small claims court, and then you may be able to obtain a judgment. Another option that isn't necessarily a separate option or exclusive, this could be joined with any of the ones I've talked about before, or it can be done separately, is possibly reporting the debt or the outstanding rent to a credit reporting agency, to one of the credit bureaus. Grant can talk a bit more about that. But this what's sort of highlighted this is that effective just a few months ago, Assembly Bill 2747 essentially gave many tenants throughout California the right to have their positive rental payments reported to one of the credit bureaus, to the credit reporting agencies. So landlords now have to generally give tenants the option or the opportunity to have their positive rent payments reported to build up their credit, right? Now, it doesn't apply to all rental units. It's typically buildings with 50, I think it's over 15 units that it applies to, subject to some exceptions. But a lot of tenants in California now have this right to positive reporting. So the flip side of that is, well, hey, if they have that right, then I should have the right to report negative, so rent. So if they're behind with their rent, I should have that right as well. And yeah, you typically do. And with that, I would turn it over to Grant to talk further about that.
Yeah. Thanks, Steve. I think the important thing to highlight here is that what you said, that this won't replace a bunch of the actions. A lot of what we'll talk about today is multiple tools. Oftentimes you can pursue them in parallel and those sort of aspects. And one of the great things about AB 2747 is it brought rent reporting to the forefront. We did a conversation with Alexandra on one of her previous webinars. We had a lot of discussions. The industry was kind of changed because a lot of us weren't consulted when this bill came out. It just kind of all of a sudden landed in our laps. And there was a bunch of notice requirements and different things that you had to abide by. So platforms like FrontLobby had to make sure to adapt to accommodate what that bill offers. And we won't dive too much into the specifics, but if you have questions on it, of course, reach out to our team. We can give you the actual notices that can comply. We can talk about how that can be implemented in your portfolio. But remember, AB 2747 is specific in California. So the beauty about rent reporting is you can offer your tenants the ability to report their on-time payments so they can use that to increase their financial well-being. All of us on this call have owned properties, may own some right now. So you understand the importance of credit when you're trying to get a mortgage, when you're trying to get an auto loan or a credit card or those sort of aspects. When you're looking at positive reporting, consent is going to be required from that tenant. It's outlined in AB 2747. Our platform requires that regardless of where the tenant is, when they're looking to have that positive reporting, we do require consent. However, when you're talking about debts from a current tenant and reporting that information to the credit bureaus, longstanding legislation allows that reporting to occur when no consent is required. So when you're using FrontLobby to report that information, you can, if a tenant all of a sudden becomes delinquent, maybe you issue them a notice, maybe you have the pay or quit option. But once that debt is outstanding for 30 days, that information can get reported so that it's actually on their credit file. And this is a really strong leverage point when you're trying to recover the debts from that individual while they're still in their property. Because if they start looking for additional housing or if they start trying to get an auto loan or a credit card, that data is going to exist on their credit file. And as a current tenant, it gets updated every single month until they pay. So when you're speaking with that tenant around this, letting them know that you're going to be reporting data to the credit bureaus before they move in is a really great first step when you're talking about screening. Once they're in their property, reporting on a monthly basis, making sure that they have the benefits of paying on time to use that to build their credit, or if there is debts, that can go on their credit file, knowing that if they do all of a sudden switch the behavior and start paying down that debt, that is also reflected on their credit file. You can see the benefits of having that on-time payment, as well as for you protecting that asset and ensuring those cash flows by making sure those debts that get reported at the same time as well. So again, when you're thinking about rent reporting, always simple rule of thumb is that when you're looking to report on-time payments, you do require consent from tenants, but when you're reporting a debt, consent is not going to be required. Just make sure you're only reporting unpaid rent and utilities that are outlined in the lease. So we'll talk a bit about former tenants in a little bit, but just remember current tenants, consent's not required, and report unpaid rent and utilities that are outlined in that lease. Okay, so the next question I want to pose to Steve on this actually is, with FrontLobby, we have different notification tools. They're always sent on behalf of landlords. Things like automated rent reminders. You alluded to making sure the appropriate person is contacting them. When a debt hits a consumer credit file, sometimes they claim this as harassment and those sort of things. So we definitely hear a lot about it on our side of the business, and I know you do as well. Maybe you can share with everyone here some of the best practices around how they can protect themselves from any of these sort of harassment complaints and what's noise versus what's best practice to make sure they're protected.
Sure. Just one follow-up on what you were talking about. So I think you said that you don't need the tenant's consent. So correct me if I'm wrong, but that means you do not need to include that particular provision that you have the right to report negative credit in the rental agreement. Is that right?
Yeah, that's right. So in California, if AB 2747 applies, there is specific notice you must apply, offers the positive. So yes. Assuming that's not your portfolio, you don't need to include, we call them clauses that you can add to your standard applications and leases. We encourage it because it provides that conversation. So if I'm applying to your property, Steve, you say, hey, Grant, that's great. I'm glad you're interested. By the way, this is something I offer. I'm going to capture your consent here. It allows you to build your on-time reporting. And by the way, if there's a debt, that's going to get reported. So it really helps on that initial screening process when you're having that conversation with the individual. Not required because consent's not required for debts, but solid best practice.
Yeah, absolutely. All right, yeah, so thanks. So protecting against tenant harassment claims. So maybe you make a demand for rent, whether that's a non-payment of rent notice or some other method, and the tenant says, "Hey, stop harassing me." Okay. As a general rule, I do not see harassment as a real viable defense to a non-payment of rent action. Rarely see that. Well, typically with the non-payment of rent evictions, the tenant files an answer or response to the complaint to the lawsuit, and they allege everything under the sun, generally including harassment. But for that to actually become an issue in a non-payment of rent case, I haven't seen it. So I don't, it's typically not going to prevent you from proceeding with a non-payment of rent eviction lawsuit. Now, it could be part of a broader affirmative. Maybe the tenant is saying, well, in addition to this demand, other things have happened that you've done to me as the tenant, and you've been harassing me, not just with this, but with other things. So maybe like an affirmative type lawsuit by the tenant against the landlord. I do see that. That's a separate issue than just trying to get your rent paid. But I do see harassment lawsuits filed by the tenant against the landlord for various things. But the reason why it's not really a viable defense to a non-payment of rent claim is because that the obligation to pay rent is really the underlying basis for the landlord-tenant relationship. And when a landlord has a pre-existing business motive here to collect the rent, to get the rent I'm entitled to, it makes it difficult to successfully assert a claim of harassment or retaliation or discrimination when the landlord is simply trying to get what they're entitled to under the rental agreement. I had a case years ago where I was able to knock that case out or the defense out when we served a notice and the tenant said, "Hey, harassment, discrimination, retaliation, all these things." And we said, "No, wait. We had a pre-existing business motive." So we showed, the landlord's pre-existing intent, and the judge agreed with us that the defense of all these various things was not viable. So generally, you don't see that type of a defense as being successful in a non-payment of rent case. What you do see, and this is really what I tell clients, that the main defenses that I'm going to see are one, there's some problem with the notice. Like I said, we had that case I talked about earlier. Maybe the notice didn't dot all the I's or cross the T's. That's one. But two, it's habitability. Breach of the warranty of habitability. That is a defense to a non-payment of rent case. And what that is every landlord in California, just by virtue of renting, has adopted the obligation to provide the tenant with a habitable premises. It means, functioning hot and cold water, heat, sufficient weatherproofing, free from rodents and pests and things like that. There's a long list, okay, of items. It doesn't have to be aesthetically perfect, but you have to have some bare requirements that the unit is in fact habitable. If it is not, then that could be raised as defense. Now, sort of the way to avoid that or to minimize the likelihood of that being a successful defense is by addressing tenant concerns. So if the tenant says, "Hey, my heater's not working," or "Hey, there's this and that," address it. Get in there, investigate, and ensure that anything that was complained about is repaired. Okay. And I'm a big proponent of doing all of this in writing. So if the tenant makes a complaint today about something, let's say you get out there within a couple days and you inspect, you fix whatever it may be, you then follow it up with in some form of writing, whether that's text or email or a letter, that, "Hey, on such and such date," there you're documenting when the complaint was made, "you complained about X. on such and such date, I came in and repaired it. Now you're documenting the time that you did it. So now you've got a nice clear timeline of the complaint and when you got in there to repair it and that you did repair it. And then saying, is there anything else that needs to be addressed? So now you're sort of kicking the ball back to the tenant that, hey, this is all I'm aware of. Is there anything else? And that, for me, as a lawyer, when I'm coming in to a case when there's habitability claims being made, that really helps me out with my case where I see, okay, it's not going to be his word versus her word or vice versa. It's going to be all documented. That's very, very helpful. And it's just a good practice. It's real simple. I mean, it can literally be a couple lines in a text or an email, something. So is that going to be absolute, is going to absolutely defend that claim? No, but it's just a good practice and it really helps us out. So be sure to address any claims of habitability, get in there, and that's going to certainly not only minimize that as a defense, but minimize harassment claims or other claims that may come about as a result of a landlord not addressing tenant complaints.
And Steve,
Yes.
there's specific criteria in each state around, in order to not pay rent, the tenant has to do X, Y, Z, and a landlord must not, fix the thing within X number of days. In your advice, like, when do you think that a landlord who has a tenant that's all of a sudden started to withhold rent, like when would you suggest they reach out to you or start pursuing in the courts versus just trying to mitigate this on their own in hopes that it will resolve itself?
Yeah, so if the tenant immediately starts withholding rent, then that's when they should take some sort of action because the law does not give the tenant in California does not give the tenant the right to withhold the rent. Now there is a very distinct repair and deduct statute, but that's not what we're talking about here. We're saying, hey, my place is uninhabitable. I'm not going to pay rent. Um, at that point, I would immediately notify an attorney or consult with someone who may be able to help you or take some sort of steps. Because in that scenario, there's usually something that's going on where maybe the landlord isn't being responsive, quickly enough, or the tenant just doesn't have the rent and is looking for any excuse to avoid paying it. That happens. Um, so yeah, immediately once the rent is being withheld, then at that point you should consult with somebody.
No, that's good. I think when I ask that question, because we see it on our side as well, from the tenant standpoint that they all of a sudden decide to withhold rent, they get reported, then they file a dispute claiming this is harassment, you don't have the right to do this, or I'm not paying my rent because my faucet's broken. And again, you're like, well, there's no communication between the landlord and you regarding this. You stop paying rent without going the proper channels and things. And you alluded to it perfectly. It's just them kind of grasping at straws, trying to find ways to get out of paying rent in those situations. And from our side, the harassment claim is used not super often, but it definitely does come up when you're doing disputes. But what I'd encourage landlords to think about is, like, disputes are just a part of when you're thinking about reporting rental data to the credit bureaus. It's not necessarily a bad thing because every tenant or every creditor has the right to dispute anything on their credit file. Similar way that if you notice a charge on your Visa that you don't recognize, you can dispute it. Or if you see, there's an inquiry on your credit file, you can, question that with the credit bureaus. And rental debt that goes on to the credit files is exactly the same. Now, the tenant can't just claim that they don't owe this and it just disappears. There is a burden of proof that goes to them around proving that they paid it. We go back to the housing provider, and again, goes back to Steve's comment on documentation. Ask to review the lease. We look for a breakdown of how that debt was calculated. Making sure that what you're reporting is accurate and up to date really helps mitigate any of these sort of disputes, harassment claims, any sort of that back and forth you'd have on a negative side with the tenant, and really helps put you in a position of being a bit more professional when you're looking at it. If all of a sudden the data that's getting reported, you have to be adjusting it down, or you're trying to claim $500 for a door that you feel was damaged that the tenant should pay. Like, that's when you start to get into trouble. But as long as you're reporting that accurate information, you have the documentation to back it up, there really isn't a concern when you're looking at the reporting side from a harassment claim or any of those other components regarding the disputes that may come in. And Alexandra, going back to your initial case that you're talking about in Alabama, like, when you told that to me, I was kind of shocked, right? They had actually reported some of the information to the credit bureaus, and one thing that came to mind immediately was that this is often a case where you see landlords that are making exceptions. So when you're looking at data that gets reported to a credit file, one, you have to make sure you actually have the right information on an individual. So, my name is Grant Burwash. If I give you the wrong, you don't take an ID from me, and I give you a false social security number or a false date of birth, again, we're seeing more fraudulent documents from that tenant screening standpoint. It's not actually going to hit on my credit file. The other thing that we hear is that tenants will put a freeze on their credit file. And so when a prospective landlord pulls the credit file, it'll show a freeze and they don't ask questions, right? Again, it's this, oh, I'm going to make an exception. I really like this Grant character. He's got a great story. Steve alluded to this earlier around making sure that process is in place. So that way, when you're looking at an individual, you're asking those questions, digging deeper so you can protect yourself from these sort of frauds. Because there is ways around it that tenants can try and file. But again, if you're following best practices, doing everything you can, relying on your community for support and kind of best tools and practices here, then it puts you in the best position to make sure that this doesn't happen to you.
Yes, absolutely. I agree. And I think really, we have two sides here, right? It's the tenant who's currently living there and what you can do when they stop paying rent, but then maybe you do get them out or they move out on their own. What are your options after they move? So that's for Steve, maybe a little for Grant there. What can we do now? Because I was looking at the chat, a lot of you have tenants who have already left. They owe you money, but some of you feel like, well, as long as they left, I don't really care, or I'm never going to see that money again, so why bother? So I think that's why we're having this webinar, because there are options that you may not know about, right? That's what we're covering. So I'd love to hear your take on it. Maybe Steve can start.
Yeah. So, of course, the first is, hey, what do I have for security deposit? How much can you deduct? Maybe that will satisfy some or all of the unpaid rent. Although in California now, with the reduction of the total amount of security deposit that you can even collect being 1 month's worth of rent, probably not going to go very far these days, but still it's something, right? So that's number one. Number two is filing a court action, whether that's small claims, depending on the amount, or a superior court action. You can always file a lawsuit to seek a judgment for the rental debt. Now, small claims court is going to be the most practical way because you can get in and out of court fairly quickly. Lawyers are not involved in that process, and it's relatively inexpensive. And again, timelines are generally, if you have a written rental agreement, you can pursue in California for that rental debt for up to 4 years. If you have an oral rental agreement, which there are still those out there, I do see them occasionally, it's 2 years. All right. So within 2 years of that rental debt becoming due, you have to file that action, that lawsuit, or 4 years for a written contract. So those are the two main methods. Another may be, sort of the hammer that, I'm gonna report this to to the credit reporting agencies, and Grant can talk a bit more about that one.
Yeah, for sure. So the statute of limitations when you're looking at reporting former tenants is slightly different. So we always recommend you have a written lease. So that holds true because yes, you can legally rent without a written lease, as Steve mentioned, but when you're looking at rent reporting, have a written lease. You can report debts in the US from up to the past 7 years. So if a tenant's moved out, let's say you just heard the webinar today and Alexandra moved out of your place 5 years ago and she has a debt, you can still report on that information. The big thing to remember with this is when you report the data to the credit bureaus, you're acting as the creditor in this situation. So, FrontLobby is not a debt collections agency. We're not making phone calls. We're not doing skip tracing. We'll talk about kind of finding an individual in a second. But what it allows you to do is a low cost option to put the debt on that consumer's credit file to again apply that leverage. And the thing to remember is often this is done in parallel. So what Steve talked about is going through a small claims court, or maybe you're dealing with the local tenancy branch. Maybe you're negotiating around how much is on the security deposits. But because consent isn't required and you don't need a claim or a monetary order or a judgment to report unpaid rent or utilities, reporting that debt to the credit bureaus is a really great first step to take to make sure you get paid. Now, let's assume that I move out and have $5,000 in unpaid rent. I skipped out on a couple months, moved out early. Now you're trying to recover additional damages. Maybe there's legal filing fees. Maybe there's lease breakage costs, those sorts of things. You can report that information to the credit bureaus, but you do need a judgment or a monetary order in those instances. And the reason being is those dollar values are really hard to determine. And so the credit bureaus have stated, rent and utilities, it's clearly outlined in the lease. It's easy to calculate, and there's kind of long-standing precedent for what would be owed. However, they're not in a position to determine how much is owed when there's damages, legal fees, lease breakage, etc. And so in parallel, you'd pursue that judgment. Let's say that dollar value is up to $8,000 that's owed to you, including the damages, legal fees, all those additional ones. You'd simply update the balance that you're reporting to the credit bureaus, and now that total dollar value is going to go on that individual. And the beauty of this as well is that you don't need current address, you don't need current employer, because we're not a collections agency, or you're not trying to find that individual. You're just looking to have the date of birth, social security number, if you have it, their full name, and the rental address that they had from you is all the information that you need to report on an individual. And so it's a really great tool that you can kind of press on them to make sure that you're top of line when they do try, make sure you're top of line in order to get paid, because it will impact their ability to obtain other credit elsewhere. Maybe a good transition here. So when we're talking with reporting through FrontLobby, you're reporting that data to the credit bureaus. Obviously, we're not a collections agency. There is a component where collections agencies are helpful. They provide additional services as far as trying to find that individual, negotiate payments. They'll do calls, texts, mail, those sorts of things. Steve, outside of collections agencies, you've talked a lot about other tools and mediums that people can use to try and find that individual to help get paid. I want to share some of those with the team here.
Yeah, so generally, and my firm, we utilize these these options here, which is one is a private investigator. Now that's not going to be the cheapest way to go. Private investigators are pretty pricey, but they're generally pretty effective at locating someone's whereabouts. They make it their practice. And another option would be purchasing some software. There's a lot of software options out there that you can subscribe to that helps. It's like a people locator, right? And you may be able to track someone down through that, that method. Another way may be just doing your own online research. You'd be surprised at how much information people actually put online, and you may be able to narrow it down and track down where that person is. But typically, what the means we use are, we'll use some legal software to try and track down the information, and typically how that works is it tracks a person's mailing address. So if someone's mailing address was your unit for 10 years, and they receive mail there, then the software picks that up, okay? And then when they move somewhere else, when they begin receiving mail, the software will then pick that up. So usually there's a bit of a lag. If the person just moved out within the last month or two, the software may not yet be picking up that new mail address. So it may take, in my experience, it's taken several months typically before you start to see the hits or results on some of the software. Now, a private investigator may be able to do so a little more quickly, but usually there is a bit of a lag when someone moves out in these online tools to find their whereabouts. But usually, if you give it enough time, it will 6 months or so, it will usually be fairly accurate. And that's another thing, they're not always accurate, but it is one method that you can try to utilize.
Great. So I saw this question in the chat, and it's something that comes up that we see as far as people saying, hey, cool, this individual owes me rent. I don't necessarily want to report them, or I don't necessarily want to do some of these other things because it makes it harder for them to find housing. And I really just want them out of my rental property. And it's I empathize with this comment because unfortunately we hear it a lot. And one of the best parts about the housing industry is it really is a community. You look at what AAOA has built as far as housing providers trying to provide information for other individuals. A big reason why we started building the credit reporting space was because we wanted to provide this information, which is historically very hidden, to other individuals. And for someone that says, "Oh, I don't want to report the information because I'm afraid this person won't be able to find housing," there's other ways you can get them out. Steve talked about kind of going through that evictions process. And so when you're looking to report them, it's not as if making it hard for them prevents them from moving on. In yes, a state like New York, it can take a long time. In California, it can take a long time to get that individual. However, your best likelihood of recovering that debt is if you continue to use all these mechanisms, put pressure on them, have the debt on their credit file, pursue the evictions process or judgments as well to make sure that you're in that top position to get paid. A similar way to think that if you're looking at that individual and the landlord's intentionally withholding the information that they owed a debt to them, and then you're the one that rents to them, that's a bit frustrating as well, right? The whole idea of having the ability to report the rental data is it's a compliant way to share with other landlords whether this individual paid rent or not. And talk a little bit here around how you can let other people know. Like, one thing I'd warn you is, like, there's been this push in the industry at various times. You've seen these groups that have popped up and then they've get taken down as far as people trying to create private landlord groups where they say, "Oh, this Grant character wasn't a good tenant, don't rent from him." And so they're trying to pool all this information. And like, that is very much a legal blacklist material. We don't want to do that. But the ability to have the rental data on the credit files is a legal way where you can share that information with other individuals without having to worry about kind of a compliance issue or those sorts of aspects. But anything else you want to share on that, Steve, around kind of letting other landlords know? How do you kind of utilize the community or some of these tools to warn other individuals around kind of the behavior of this individual while still keeping yourself protected?
Yeah, I think first and foremost, like you mentioned, the reporting to the reporting agencies is a good way to get that out there. Presumably future landlords are checking the credit, and they'll see that, and then that right there is putting them on notice of this particular tenant's rent history. So what about the sort of the reference based disclosure, or giving notification to a future landlord? Well, first, here's the concerns, is that somehow what is being disclosed to a future landlord, if the tenant finds out that there could be a threat or an actual claim against that prior landlord for defamation or interference with contract, some adverse claim or action by the tenant against the landlord. So the ultimate defense to those claims or lawsuits is the truth, right? If you're telling the truth, then generally that there's no merit to those particular types of lawsuits or threats. So first and foremost, if you're going to disclose any information about the tenant's rental history, be sure to tell the truth. That's a defense to these types of potential claims by the tenant. Another is, don't volunteer anything that's unnecessary. Right? Like right there, I think Alexandra put, don't vent publicly. Same thing, if you're talking to a prospective landlord, don't say, "Well, yeah, the tenant was disabled and they needed an emotional support animal." You don't have any. There's no reason to say something like that. That opens you up to potential claims for disclosing private medical information, right? Just stick, directly with the rent history. Just focus and be very narrow on what you're disclosing, and don't volunteer anything that could get you in trouble. So just stick to the facts related to that contractual landlord-tenant relationship. And then, the other thing that, look, if you just say, look, I just don't want to subject myself to potential issues from, this prior tenant. I don't want that tenant to come back ever, whatever it may be. Then some landlords will just say, you know what, I'm not going to talk to a future landlord. I'm just going to keep this to myself. If they ever reach out and get a hold of me on the phone, to simply have the simple response that it's my policy not to comment on prior tenant relationships. And then that then would potentially shield from any claim that the tenant is trying, excuse me, the landlord is trying to prevent the tenant from future rentals. Now, of course, that is not very helpful for other landlords, is it? That, as we talked about at the beginning, how important it is to vet, and that makes it more difficult. And that's why, again, sort of this reporting to the credit bureaus is one sort of maybe perhaps safer way to address this situation and put the world, so to speak, on notice of that tenant's rent history.
Alexandra, I was listening to one of your last webinars. You talked a lot about screening. We talked about some of those aspects. What do you want to share on this? I know you've got some insights.
Absolutely. I think there are so many myths circling about how credit reports work. And for some reason, people seem to still think that things just happen automatically. So even if you were successful in obtaining the eviction and the judgment, following those steps Steve was going over, that's not going to make it to the credit report on its own. That's not going to happen automatically. In 2017, those were removed from credit reports. So you do need to be proactive in reporting through FrontLobby, through a collection agency in some way, if you want that to affect their credit report. The other thing I'll mention as well, which was coming up in the chat quite a bit, there's also a big misunderstanding, and Steve, I'd love to hear your comment on this, to whether or not you need a social to report a debt, which you don't, and also whether or not you need a social to run a credit report, which you also don't. But you do need to have at least an ITIN number to do that. Now, the concern in California, and there's other states as well, is there's now local or state laws that hint that you should not inquire into someone's citizenship or immigration status, which leads some people to believe that therefore you cannot even ask for their social or ITIN number. From my understanding, you can ask for it, you can't require it, and then having that social is good for you in the future if you do need to pursue the debt. Obviously, if you don't have it, you can still do that. It just makes it a little harder. So Steve, I'd love it if you could clear that up. I know that's not really the topic we have today, but there was quite a bit of back and forth in the chat as to whether or not you can even ask a tenant for their social or ITIN number.
Yeah, so the fair housing laws in California are so strict, and they protect so many different characteristics of individuals. And as you point out, that does include citizenship in many circumstances, and of course, ethnicity and things like that. And so the general rule is, yeah, you don't want to condition anything, the rental on anything that would have the appearance of even deterring someone from applying. So the example I give is if you have if you ask for that social security, if you say, hey, I want to see the social security number, or I want to know certain information, if it's possible that even requesting that would deter even one person who's a member of a protected characteristic, it's arguably discriminatory. So you have to be very careful about what you even ask for, let alone condition. And I'm seeing, and I just got off a call with a group just this morning before this talk about these organizations that are sending texts out in response to apartment listings looking for exactly that, just some rejection on something. And then they are immediately filing a fair housing claim against the landlord and demanding a lot. There's one particular organization that's not even based in California. They're in New York. And we've already had a landlord who got hit by a claim and now have a second one. So they're a fairly new organization that I have not seen before. And they're demanding well over six figures for the rejection of someone um, when that rejection is arguably could be determined as discriminatory. And again, the listing or the statement doesn't have to be overtly discriminatory if it has the effect of even deterring someone, whether it does or not. It's discriminatory. So you have to be very, very careful.
Yeah. And as far as, with our screening, for example, if you choose for the tenant to pay for it, they're going to be typing in their own social and ITIN. If they don't type it in, there's no credit report that's going to come back because that's the only way we can pull a credit report. So essentially, you could have them pay for it and not, if they don't type in their social or ITIN, no credit report comes back. Then Steve, if I require there to be a credit report, is that now discriminatory?
That may be a case by case basis. My initial reaction is no, you are entitled to a credit report. Um, but it does not put it past me to believe that there would be a potential claim of discrimination when a tenant cannot provide a credit report. In that circumstance, maybe you make it available that you would accept a guarantor, as an accommodation in that particular circumstance, or someone else to provide their credit in order to verify the income and the credit. Um, but generally, no. My understanding, and you're making me think about it. I may have to think about this a little more. Is that you are entitled to some sort of background, credit and income history in general. And again,
Yeah,
there's even exceptions to that with income when it comes to a Section 8 tenant and
right.
credit report. But in general, yeah, yeah. So Section 8 aside, I think you're generally okay, but I have to rethink that. Yeah.
Well,
Yeah.
let's assume it's not Section 8. One thing I've seen a lot more, Steve, is people publishing what their requirements are. And therefore, it's not deemed discriminatory. So if you don't have a credit score, it's not that I'm discriminating you for being new to country or not having a credit. It's that my requirement is you have to have a credit score of X amount. You have to be one person has to be fully employed, or you have a guarantor or something like that. And I believe that a lot of that is to protect against some of these discriminatory claims that have been coming out.
And
Certainly.
even that, even publishing that information these days, again, I do not put it past one of these organizations to look at that as potentially deterring someone from applying.
Mm.
Yeah. I suppose anyone can make a claim, whether it's successful or not is another story, but it still, puts you in the place of having to defend it, which is not ideally where we want to be. So you can do everything right and still have a claim. But you should also be proactive in making sure you can prevent it when possible. And I think that's a really good point, just to kind of wrap all of this up, is that um, credit reports are still valuable. They're still important. And it's very important as well to make sure that you're reporting this information to the credit bureaus and credit reporting agencies. We really need more information for ourselves, but for other landlords too. So make sure that if, those of you going back and forth as to whether it's even worth it, it can't hurt to report it, in my opinion. So I think that's a great way to kind of segue here into our last kind of Q&A section. But I also wanted to share the results from that poll earlier. We asked you at the beginning if you currently have a process for handling unpaid rent. And at the beginning of this presentation, only 13% of you said that you did have a process and that it works well. And the rest of you did not. So I hope that those other, 90, almost 90% of you are looking at implementing some of these processes into this whole unpaid rent process where you're really handling it like a business. You have everything thought out in place beforehand. So with that said, I'm going to go ahead and start up with some Q&A. We'll just do a few questions and then we'll go to a few other slides. Actually, Grant, why don't we go to the next slide real quick so we can share the information here. So we have Steve's information. By the way, we are recording this, of course. We're going to email it to everybody tomorrow. So you'll get Steve's contact info in there. He does work in the Bay Area, specifically in California. It certainly could help you with any questions in that area. And his info's here. We'll share it with you all tomorrow in the email as well. And then on the next slide, we have FrontLobby's information, which I'm seeing a dark screen here. There we go. There it is. There's this FrontLobby's information. I'll let Grant speak to a little more about what FrontLobby has to offer. He kind of talked about it a little bit, but we have a QR code here, an offer. Grant, you want to explain a little bit here before we get into Q&A?
Yeah, sure. The 20-second story here is we're giving our best deal here of the year to AAOA members. The premium membership year, it allows that we're talking about the discounted price for $200 a year. It allows you to report on up to 20 current tenants every single month. So that's their on-time payments and that's the debts. So it really is the best place to go to help protect you to ensure that rent is paid. We also offer, as I mentioned, the ability to report former tenants' debts. That's a low one-time fee. There's other options for us. So feel free, write that code down. We'll send it out tomorrow. FrontLobby.com. We're always here to help, so we can't cover everything today. So some of the specifics around your specific use case, you can always book time with one of our team members or send us an email, and we'll be happy to follow up and reach out to talk about your specific situation. So that's what we talk about here.
Great. Okay. I honestly think booking a call is the best way to go about this because I know a lot of the questions in the chat are very specific, and I'm probably not going to touch on some of those very, very specific Q&As that we have. I'm going to try to look at some of the ones that are a little bit more general because honestly, you have a really specific situation. FrontLobby can point you in the right direction as far as how to report that debt, or if you have a current tenant, how to get started on reporting. So I put up a poll question. If you say yes there, that works. We'll connect you with the FrontLobby team. You can also scan the QR code. And then of course, we're going to send it again in the email tomorrow. So you'll have that. So let me leave that up for just a little while. FrontLobby does work in all 50 states, right, Grant?
Yes.
Okay, great. So that's good to know. We'll go back. Well, we could leave this screen up if you want, Grant, and I'll start taking some questions here for you guys. So, Robert, is there a service that would fact check a lease? Do I need to find a real estate lawyer on my own? Steve, what do you recommend for having a really solid lease? Is the attorney route the best way to go?
No, there's a lot of organizations that publish rental agreements, and that's what and I generally don't invent and reinvent the wheel. When someone comes to me with a rental agreement question or they want us to prepare one, I generally look to one of these organizations and use the forms that have already been created and updated annually, and then I'll specify it or tailor it directly to that particular client's needs.
Great advice. Sophia says, can the landlord continue adding the daily late payment fee to the rent owed after the tenant has left? For example, if it's a $5 late fee after the grace period as per the lease contract, that might vary state to state. But Steve, what are you seeing as far as late fees go?
So I have a problem with that one. A $5 daily punitive clause for a late rent payment is likely not going to fly in California. It's likely punitive, which would render it unenforceable. Typically, what you want to see is a one-time late fee that is, a reasonable estimate as to what your out-of-pocket cost would be for someone not paying on time. So gone are the days of like a 20% late fee. Usually looking at just the rent's $2,000, maybe you got a $25 or $20 late fee, something more along those lines. So a daily, that's not going to fly, but a one-time small amount would probably be enforceable. But again, what are you going to go to small claims court over $25? Typically, you join that together with other damages as well. But the amount needs to be a reasonable amount.
Michelle asking, maybe for Grant here, I have one tenant who didn't pay their share of utilities fees, since it's not included in the rent. First of all, my question to add to Michelle's is, can you report that to their credit reports? And then for Steve, can you take a tenant to small claims for those utilities?
Yeah. So when you're reporting the information, as long as utilities are outlined in the lease, you can report those. And there's utilities often show up in either a lump sum or it's a percentage or, exact charge, whatever that is. So yes, those individuals that you report on the utilities, and you can also report that on all the tenants that are signatories on the lease. So as a landlord, you don't necessarily know whether Steve or I didn't pay our portion of rent. We're both signatories, and so you're reporting that debt on all signatories of the lease. And that can include a guarantor as well.
Mm. And what do you think about taking that to small claims?
Yeah, that's
Steve?
definitely an outstanding debt that can be sought in a small claims court action. Just note that some jurisdictions prohibit, if this is a utility sharing situation, if it's you're sharing and it's their portion of utility, some jurisdictions preclude landlords from charging that, and also some preclude from charging certain utilities altogether. So you just need to make sure that you're entitled to that particular utility and that method of utility charge in that jurisdiction.
That's a good clarification, especially in those rent control areas where you can't charge.
Absolutely.
Yeah. Min asks here, rent is paid by an occupant, tenant's sister. She signed paperwork admitting that paying rent doesn't make her a tenant. So I think the sister is paying on behalf of the occupant. So in this case, if a 3-day notice is to be issued, should it be issued to the tenant or to the tenant's sister who is paying the rent?
Yeah, so I always advise that you name the tenant on the lease, and then anyone else who may be there. This person has already said, well, I'm not really here, I'm just paying whatever, maybe they live out of state, who knows. I generally, depending on the circumstances, would not recommend including that person in the non-payment of rent notice. But there's a catch-all. And when I send a process server out to serve a notice to pay rent or quit, we serve 2 copies. One is to the named tenant, and the second is to anyone else who may be occupying the property. So we're not only getting that tenant, we're getting, maybe Jane Doe, the sister, or maybe he has a wife or a girlfriend or something living there, and we're getting that person as well. And then that makes it easier for us to name that person as a defendant if they resurface later and say, wait, I live here too. Well, you were given the notice. So, and if you're in a rent control jurisdictions, there's actually reasons not to name a subtenant or this particular person who may or may not be living there.
So this is an interesting one. For a short-term rental, like an Airbnb, what establishes residency? There are rumors on the internet that receiving mail or Amazon packages establishes this, but I don't agree. I'm in Ohio, but we're no trendsetters in anything.
Mm-hmm.
Is there? So I think really, short term. What if somebody doesn't leave? What happens? Have you seen that, Steve?
Yes, and incidentally, this happened. I don't know if you read about it a couple years ago, down in Southern California, maybe in Hollywood or in the Hollywood Hills or Beverly Hills area. It was a very fancy house owned by a dentist down there who rented to short term to somebody who didn't move. And fast forward over a year, that person was still there. And incidentally, that particular person who was squatting happened to be a former tenant that we evicted up here in Northern California. So here's a sort of an example of a serial tenant. We evicted that tenant for non-payment of rent. So in general, in California, once they get in there, even if they're a short-term renter, if they don't move, you're not going to be able to go change the locks and put them on the street and put their stuff out. You're going to have to avail yourself of the unlawful detainer process. So they have essentially tenant rights from the moment they step in.
Unfortunately, FrontLobby support. So I think this came up a lot in the chat. So someone from the FrontLobby team suggested we ask this to you, Grant. In California, is it illegal to share negative reporting of tenants to other landlords or credit bureaus?
No, it's not. So a lot of the confusion in California, specifically around debts, came out with AB 2747. Those are two completely separate issues. So the FCRA, the reporting to the credit bureaus, it allows landlords across the US to report accurate and updated information to the credit bureaus. That includes debt without consent. So that is true. In California, it talks about the tenant's ability to opt out of participating in positive rent reporting through AB 2747. So if you remember a while ago, I talked about adding our clauses to the leases. There's notices with AB 2747 where you give a tenant the ability to participate in this program. They can then choose to not. So even if they sign that saying, hey, I want to have my on-time payments reported, they can choose to stop at any point in time and they can't re-enroll for 6 months. However, if then they stop paying their rent, you can continue to report the debts. So the ability to report debts on the current tenants and former tenants is still allowed in California and every other state as well.
Thank you for clarifying that. And then, yeah, I like that you said, and for every state as well, because I see in the chat people saying, well, what about Michigan? What about Minneapolis? So California is the only one who's done this. To no surprise, right? They have this new law. Outside of California, though, there really isn't, at least for now, any laws that I'm aware of that specify anything about rent reporting. So I'm glad you mentioned that.
And there will be other ones. There's proposal that's coming out. So I would expect, and the language mirrors AB 2747. There's slight adjustments and things, but you're going to see this continue to get more and more exposure, especially as kind of Fannie Mae and Freddie Mac and a bunch of these other places are starting to change how they're viewing it, and the recognition around credit reporting for rental as being a really big initiative that people want to see. You're seeing in the buy now, pay later space as well. The desire to have that included on credit files is another push that you'll see on the credit space in the next couple of years.
Yeah, I can see that. California usually starts things. Nadira here asking, if there are 3 people on the lease, how is rent reported? Is it for one person or for all 3?
All 3. So all signatories, they all get reported. So let's say rent is $1,500. Every individual will see that $1,500 report on their credit file every single month because they're all legally responsible for the entirety of that rent amount.
That makes sense. Robert asking for Steve, does the lease apply once they become a month-to-month tenant? This was in reference to that comment that you need a written lease. California is different than I think other states have different laws on this, but what do you see on your side, Steve?
Yeah, so let's say the lease term ends after 1 year. Then it just the terms and conditions of that rental agreement carry on a month-to-month basis thereafter. Now, you can certainly renew it and extend it to another term, but you're not legally required to do so. So yes, that lease does still apply. It remains in effect after the initial term, but just on a month-to-month basis.
Okay, great clarification there. See here, I had another question come up about background checks in Ohio. How far back can a landlord check for criminal records? I turned down an applicant down because of his drug history. What do you know about how far back we can check? I can speak to our screening goes back 7 years for any convictions. But I know it's tricky to decline someone based on criminal records. Steve, any advice there?
Yeah, so technically throughout California, it is not yet prohibited from rejecting someone based on criminal history, but there are certain areas now, Berkeley and Oakland, and it's just a matter of time before this spreads, that does preclude landlords from rejecting tenants with criminal histories or even looking into the criminal histories. So in general, you can still, throughout most of California, you can still vet for criminal history and reject someone on that basis.
Good to know. Here's another one. If the tenant owes us more than $10,000, should we still do it in the small claims? And if the amount has exceeded the security deposit, how do we recover it? For Steve, I assume.
Yes, that's a good question. So if the amount exceeds the small claims court limits, here's what I usually tell a client. Are we talking, is it exceeding it by a few $1,000s? If that's the case, then it's probably going to be financially worth it to just, you know, I don't want to say give up that additional money, but just pursue it in a small claims court action, avoid the attorney's fees and avoid the costs of a superior court action. But if it's a substantially amount, if it's substantially higher than the small claims limits, then you're going to have to make a decision. Or do you want to file a superior court or the small claims court? And that may depend on your understanding of the tenant's collectability. If we're talking about a deadbeat tenant, which in most non-payment rent cases, that's the fact, that's the case, then you may be throwing good money after bad money. So really it needs to be determined, does that tenant have any assets? Are they even worth going after or spending a bunch of money to go after in a collection lawsuit? And that may help dictate whether you pursue small claims or superior court.
Good perspective there. Bobby is asking for Grant, what if the utilities are included in the rent? Is the full amount reported to the bureaus?
Yeah, when you're looking at positive reporting, when the utilities change each month, usually that doesn't get included on the positive side because rent gets reported retroactively. So meaning, in August, you're going to report the rent from July. Usually what happens if his rent is $1,500, everyone gets the benefit of having that $1,500 on their credit file. Now, if there's an additional, call it 150 that you have for utilities, you just simply input the rent amount as being 1650, and then everyone gets the benefit for paying their rent and the utilities. So on the positive side, it can work that way if you do have a clearly defined dollar value that utilities are every single month.
For all of you putting any questions in the chat, if you could please move your questions over to the Q&A box so I can better track it. The Q&A box should be at the bottom of your screen. You just have a few more questions left in Q&A, but I see some activity in the chat. I'm assuming are questions. So if you could move your questions over to Q&A, we can maybe ask a few more here, although we are way over time. Thank you guys for staying to answer questions. We'll answer just a few more if you want to put it in that Q&A box. Regina, tenant has not paid rent. She says, because I need to fix the dryer. That's a funny one. The other one I saw in the chat like a while back was somebody said that they were claiming a habitability issue because one of 4 bathrooms was not working. So what do you do when you have these sort of bogus habitability claims?
So yeah, that now again, you need to look at the jurisdiction you're in because while it may not be a habitability issue, it may be a housing service as defined under a local rent control jurisdiction or rent ordinance, which does impose obligations as well, and tenants may be entitled to some sort of a rent reduction. But withholding rent for a dryer repair or for something, again, you cannot withhold, generally in California, you cannot withhold rent. You can do what's called repair and deduct. But in general, you cannot withhold rent, so the landlord can be a little more aggressive in those scenarios. That being said, I would still, if you provided a functioning washer and dryer at the commencement of the tenancy, then you should probably go out there and have it fixed, especially if you're in a rent control jurisdiction. The bathroom, now, technically, if they have 4 bathrooms and there is one that's not working, that could be still a habitability issue. So definitely get out there and repair that.
Right. Marion says, our apartment building is in a business entity name. Can I change the ownership to my personal name and transfer the unpaid debt to myself and pursue the small claims court?
I see. So yeah, there is generally a right to assign debt, and I do see that occasionally. And I'm assuming you want to do this to avoid the reduced statutory minimum. There's a lower amount you can seek in small claims court if you are a corporation. So you can give that a try where you assign the debt to someone and then have that person actually file the small claims court action, and then you can seek a higher amount. As a general, yes, you can do that.
Interesting. Robert asking here, if I give the tenant the option of using my appliances, or to have me remove them and they destroy it or something and it no longer works, does that allow them to complain about habitability?
So you've okay. So in general, no. So habitability applies to um, issues or defects that arise, generally common wear and tear, or things that are not the fault of the tenant. If the tenant is the one who has caused the habitability issue or the damage, it is the tenant's responsibility to pay for that repair. Okay. So no, that does not give the tenant the right in that circumstance to complain, though it won't stop them from complaining. But you have a reason to say, hey, you need to make this repair, not me.
Yeah, absolutely. It still won't stop the claims, but you know. Charles says here, you said California had capped the security deposit to 1 month. Maryland has done this, and it includes the pet deposit. Is this a trend? I'm in Virginia also with a 2 month cap, and this would be a problem. I'll speak from kind of what I'm seeing too is yes, it is a trend. I'm absolutely seeing that in multiple states. California is not the only one where there are limitations now for security deposits, including the pet, deposit, pet fee, whatever you want to call it. That's a whole other portion here of some of the laws that are coming up and addressing pet fees. So certainly it is happening more and more in other states, and I don't expect that to stop anytime soon. The 2 months seemed to have been pretty aggressive back in the day when California passed it, and now 1 month, it's like they want to just make it smaller and smaller there to really relieve the tenant of having that to pay that money up front and make housing more accessible for them, especially because rent is higher than it used to be. So 2 months rent is a lot more of their income potentially than it used to be. Steve, on your end, you're in California, obviously. How have people been reacting to the 1 month security deposit?
I don't know that it's hit a lot of people yet. I don't know that they are realizing it, but it's just sort of unfortunately, most people in the business know, hey, this is California. This is the way it happens. Generally 99% of the laws that come out are in favor of tenants. Rarely do we get some legislation that is beneficial to the landlord. So it is, unfortunately, business as usual. But what some people don't realize, which you hit on, is that yes, this includes last month's rent or a pet deposit or any other, cleaning deposit. No, it's all rolled into one. It's all a security deposit, and in total cannot exceed 1 month in California.
In California, at least for now. Jackie says, my military tenants did not notify me of the relocation until they moved out, and they asked me to deduct from the security deposit. I don't like the idea. How can I pursue the delinquent 1 month rent? His supervisor in the military is not responding to my emails. Who can I go to pursue the lost rent?
Well, I'm unclear as to why you wouldn't use security deposit.
Yeah, I think unless they have damages, right? I suppose if there were damages left behind, you might need the security deposit for that and still not have enough to cover the rent. Maybe that might be
Yeah,
part of
yeah,
it.
that may be the case. But I would first and foremost use a security deposit. Make sure you do so within 21 days. If this is California, you account for it, make all the deductions. Anything in addition to that, if you're entitled to it, you can bring a small claims court action.
Okay. Yeah, Jackie said not enough to cover the repair. So yeah, that makes sense. Here's another one, and I think we might end with this one I mean, there's plenty more questions, but I think just with the time given, I want to just finish with this last question here, which is, where can we report a tenant who has not paid their rent, skipped multiple months, and has been evicted, apart from filing in small claims court? This is why we're here. FrontLobby is the rent reporting agency that is hosting this, sponsoring this, and I'll hand it off to Grant to give you a little bit more information. I know we already covered it, but just to close up the webinar, even if you want to go back to that slide, Grant, feel free. You can maybe give us the final summary here.
Yeah, sure. So if you have a current tenant that owes you a debt, you can report that through FrontLobby. That's going to get reported on an ongoing basis. They also have the ability to report their on-time payments as well. So if you are dealing, unfortunately, in that situation where someone owes you rent, go ahead and do that. I was just pulling up the slide here again. When you're looking to report on that individual, we do have an offer. So there's the code W199US that gives you $40 off our premium membership, which is what is required to report current tenants to the credit bureaus. Now that allows you to report up to 20 current tenants every single month, positive or negative, or sorry, 20 leases every month, positive or negative. If you have a former tenant that owes a debt, you can also use us. As Alexandra said earlier on, probably best to book a call with us or reach out to us so we can talk about your specific situation, make sure we can provide you those best options. And, also important to remember that this often happens in parallel with working with someone like Steve, working with a small claims court, those sort of aspects. So these are a wonderful tool. They definitely help reduce late payments, get you paid, but they don't always work. And so as we talk about oftentimes in these sorts of conversations, be proactive, be human, be smart, protect yourself, and use all the tools at your disposal.
And I do have a question for Grant that I think may be helpful. Of course, if you're reporting this debt to the credit reporting agency, you want the tenant to know that that's been that's been reported. What's the process when you report it? Is the tenant then somehow notified of either a positive or a negative reporting? Is there some letter or something that goes out where that tenant is put on notice within a certain time period?
Yeah. So when you use our platform, you can enter the tenant's email address. And so when you initiate using the program, it does automatically notify the tenant. That's not optional. Now, of course, whether if their email, they check it or not, you can see whether they've clicked on it, but you're not legally required to notify the individual. We try and encourage that because it drives positive, proactive communications. We have the ability for the tenants to view their lease record and all the information that's getting reported for free in the platform. They may also use services like Credit Karma or directly with TransUnion or Equifax monitor their credit files. And so usually they will find out about it in some sort of way fairly quickly. That being said, AB 2747, again, California being different, there are legal requirements for you to notify the individual, which we provide specific documents which you should put in your lease and those sorts of things. So that is kind of the one outlier as far as making sure you notify them. Otherwise, we provide these tools like rent reminders, tenant notices, which all go out from you to the tenant, just to drive that communication that we've talked a lot about on. So when someone is late or going to be late, we just want to have that conversation. You want them to reach out and say, hey, I'm struggling. Let's get on a payment plan, or I'm going to be a couple days late, but I'll pay you on Friday, those sorts of things. So those tools definitely are in the platform and can be used for that instance.
Yeah, and I think that is so helpful because that's what we started with, right? Was communication was one of the first steps, and the FrontLobby platform makes it really easy to provide that communication. So definitely check that out. And then also too, I'd like to mention this whole thing is recorded. We're going to send you everyone, and regardless of whether you sent your email or not, we have your email. So you registered for this webinar. So we're going to email it to you tomorrow, and we're going to give you the slides, Steve's contact information, that FrontLobby offer. Someone else had asked as well if FrontLobby can do like non-membership, so just like a one-off report of a debt. And my understanding was that is possible, but it's nice to have the system on an ongoing basis to use those communications we were talking about for your current tenants as well, to make sure, maybe you are helping them out with positive reporting that could really help you also in the long run. And one statistic that stood out to me so much, Grant, that I saw on your website is that 96% of tenants that FrontLobby reports on a monthly basis pay rent on time. That is so crazy high. I mean, if I had a portfolio of rentals with a 96% payment rate, I'd be happy with that. It certainly is, a great tool for dissuading people from not paying their debt or, their rent. So certainly reach out to the FrontLobby team. I'll send you all that email, and reach out to Steve as well with any of your California legal questions. Their team is fantastic, specifically in the Bay Area, but Steve seems to know quite a bit about all of California as well. So thank you both for sticking around for so long and answering all these questions. And for those questions we didn't get to, I'll email the questions to Grant's team and any relevant for Steve as well, so we can answer those after the call.
Great. Thank you, Alexandra. Thank you, Grant. Thanks for having me.
Wonderful. Thank you for being here. And everyone, please take the exit survey as you leave. We do have another webinar this week on Thursday on the One Big Beautiful Bill Act and how that will be affecting rental property owners, specifically your tax strategy. We're going to go over everything you need to know. That invite is also going to be in the email tomorrow. So lots of good stuff coming to you. Check your emails, check your junk, check your spam. It might go there. Don't miss it, because I'd love to have you guys on the Thursday webinar as well. Anyway, everyone, I hope you have a wonderful day. Take care, and we'll see you soon. Okay, bye.
Thanks.